The man sitting across from Congresswoman Dean today was paid $10 million to defend Donald Trump, and now he runs the Justice Department. What you're about to see is Dean walking into that hearing with 3 million buried documents, a dead victim's final words, and one question the acting attorney general could not answer. She's accusing the DOJ of knowing exactly who Epstein's co-conspirators are, and choosing, deliberately, not to prosecute a single one of them. She went to the Department of Justice 3 times, spent nearly 10 hours in a locked room, and came back with pages so blacked out she used up all the ink in the hallway just trying to find the truth. This isn't about Jeffrey Epstein anymore. It's about who the Department of Justice is actually protecting, and why. Let's get into it, and I'll give you my take at the end.
Ms. Dean.
Thank you, Chairman Rogers. Thank you to our ranking members. Welcome, Acting Attorney General. I want to speak about justice for the Epstein victims and survivors. And I'm going to begin with the closing words of Virginia Roberts Giuffre in her book. It's literally the last paragraph. She writes, "I hope for a world in which predators are punished, not protected. Victims are treated with compassion, not shamed, and powerful people face the same consequences as anyone else. I yearn, too, for a world in which the perpetrators face more shame than their victims do, and where anyone who's been trafficked can confront their abusers when they are ready, no matter how much time has passed. We don't live in this world yet. I mean, seriously, where are those videotapes the FBI confiscated from Epstein's houses? And why haven't they led to prosecution of any more abusers?" That's from Virginia. It was printed, as you know, posthumously after her death. Mr. Blanch, you and I had a chance a couple of weeks ago at the Department of Justice to speak about these cases. We discussed 3 things in connection with this monstrous, decades-long crime spree. Number 1, your failure to fully redact survivor information. Number 2, your failure to follow the law and release the remaining files. And number 3, your refusal to prosecute anybody else. Mr. Blanch, let's continue that inane conversation, but this time it's public. This time, and more importantly, it's under oath. You're speaking to Congress. So let's get into it. When will you comply with the law and release all of the files?
As I said to you when we spoke before, we have complied with the law. We have reviewed.
There are 3 million more documents, and you know what you said to me? They're all duplicative, and they include another guy named Epstein.
No, I didn't
Nobody's
say that.
buying. That's
I did
what you
not
said.
say that.
That's what you said.
So look,
reclaiming my time.
Can I answer? Can I answer the question?
No, you may not. I
Okay.
just gave you the answer you gave me.
Telling.
No, actually, it's my time, Mr. Chairman. I think those are the rules of this committee. I told him the answer he gave me, and now in public he's trying to say something else. Please stop the clock. Can I get that time back? May I have 20 seconds back, Mr. Chairman? Thank you. I very much appreciate that. Mr. Blanch.
You don't want me to answer the question.
Mr. Blanch, as you know, I visited DOJ 3 times for as much as 10 hours, and I'll be going back. Does the Epstein File Transparency Act say that the files should be available to members of Congress with a minder at DOJ, where you're in a secure room, you can't write on any of the binders, you can take your own notes? Is that what the Transparency Act says?
It doesn't require we allow you to come to DOJ at all. We did that on our own.
What does it say in terms of transparency? It says that they should be made publicly available.
And they were.
Am I correct?
And
publicly
they were.
available.
And they were.
Oh, well, let's talk about that.
Okay.
Time of the gentlelady has expired.
I beg your pardon.
2 minutes and 10 seconds.
And I'd actually like to get 20 seconds back. How do I get cut off 2 minutes into this?
2 minutes and 10 seconds left.
Time of the gentlelady has expired.
I beg your pardon, Mr. Chairman.
No, that's not right.
What rules are we operating under?
That's not right.
Because he's under a little bit of heat for not prosecuting anyone in these monstrous crimes? I've been in the room. I have been there. This is what I had to do, to transcribe, to show what is true. What is true is that the president has lied about being on Epstein's plane, and the unredacted files prove that. There's a lot in here. I am shocked at this. There's also this set of files in the file. This is investigation into the potential co-conspirators of Jeffrey Epstein. I almost used up all the blank ink in the hallway because it's all covered up. It's all covered up. The American people are not stupid. They know that when members of Congress have to go in and actually unredact to try to find the truth for these victims, something is corrupt. Something is corrosive. You were paid $10 million to represent the president. You hang a 30-foot banner of the president's menacing face over the entrance to the Department of Justice. You said that if you were terminated or not moved forward as Attorney General, you would say to the president, "I love you, sir." So I have one question for you. Is your obligation to the victims and survivors of Epstein's heinous crimes and all his perpetrators, or is your first obligation to the President of the United States?
So without a doubt, we want to bring justice to every victim.
When will you bring that justice?
Can I please finish?
Excuse me.
Can I finish?
It's been decades. When will
Can
you
I
bring,
finish?
When will you bring the justice?
So as I was saying,
When will you prosecute?
Oh,
And who will you prosecute?
can I
Please
speak?
allow the witness to answer.
You told me in our
So I'll tell
conversation you
so
blamed the victims.
Every victim
Let the record
of Mr.
reflect,
Epstein.
he told me
of-
that the
of-
victims didn't give good names.
let me be crystal clear that this Department of Justice will always protect victims and will always prosecute anybody we can, okay? Full stop, no ifs, ands, or buts, okay? What you are showing in a game of showmanship are redactions because of victims, because that prosecution memorandum
Perpetrators.
talks about, excuse me?
Perpetrators, too.
How do you know that? Go ahead.
Talk to the
Exactly.
victims.
So
Talk to the victims.
they're victims' names, which we are required to redact, required by law to redact, which we did. Okay? So I take
Mr.
umbrage
Chairman,
to
I
the
realize
idea.
I'm over time. I thank you for that indulgence. I want to ask for unanimous consent to enter records into onto the record. May I do that now?
Without objection.
Thank you. The
Time
first,
of the gentlelady has expired.
Okay, let me validate what you're probably feeling right now. Because if you watched that exchange and something felt fundamentally broken, you're not wrong. I want you to understand the specific mechanics of what just happened, because once you see the structure, you can't unsee it. Let's start with Todd Blanch, because who he is explains everything that follows. Before he became the acting Attorney General of the United States, Blanch was Donald Trump's personal criminal defense attorney, not a career DOJ official who rose through the institution over decades. A private attorney who was paid, according to Representative Dean's direct statement in this hearing, $10 million to defend the president in criminal proceedings. And now that same man sits at the head of the department that is constitutionally supposed to be independent of any president. I want you to hold that fact as we go through the rest of this, because it is the lens through which every answer Blanch gave today needs to be read. When Dean asks him whether his first obligation is to the victims of Epstein's crimes or to the president, she is not editorializing. She is identifying a structural impossibility that the Senate confirmation process failed to stop. You cannot have spent years as someone's personal defense attorney, collected $10 million from them, and then credibly claim that your decisions about who gets prosecuted carry no trace of that relationship. That conflict of interest is not a theory, it is a resume. Now let's get into the Epstein File Transparency Act, because this is where Blanch's position doesn't just look bad, it collapses under the weight of his own words. Congress passed this law to compel the public release of documents related to Jeffrey Epstein and his network. The operative phrase in the statute is publicly available. Dean reads that language directly back to Blanch in the hearing. He confirms it, and then tells her they have complied. So let me tell you what compliance actually looked like in practice, because the details matter here. Dean visited the Department of Justice 3 separate times. She spent nearly 10 hours in a locked, secure room with a DOJ official she calls a minder, supervising her access. She was not allowed to write on the binders. She was not allowed to take copies out of the room. And the pages were, in vast portions, entirely blacked out, redacted so thoroughly that she says she used up all the ink in the hallway just trying to transcribe what she could see. When she asked about the 3 million documents the DOJ still hasn't released, Blanch reportedly told her they were all duplicative, just copies, and that some involved, quote, another guy named Epstein. Nobody is buying that, because publicly available does not mean members of Congress can visit a secure room under supervision and look at mostly black pages. Publicly available means the public can access them. That is what the words mean. What the DOJ has offered is not compliance. It is the performance of compliance, and that distinction is everything. Now, I want to address the redaction argument because Blanch does have a defense here, and it deserves to be examined before we explain why it doesn't hold up. His argument is that the redactions protect victims, that the names of trafficking survivors appear in these files, and releasing them without consent would cause serious harm. In principle, that is not wrong. Victim protection is a real legal obligation with statutory backing. But here is the problem Blanch cannot talk his way around. Dean is not holding up the victim files. She is holding up the investigation into Epstein's potential co-conspirators. Co-conspirators are not victims. They are the people who allegedly helped Epstein build, run, and protect his network. If those redactions are protecting victims' names, the question that demands an answer is, why are victim names appearing in a document about the people who abused them? Blanch never answers that. And the reason is that the more credible explanation points somewhere more uncomfortable. The redactions in the co-conspirator file are not protecting victims. They are protecting names, powerful names, names of people who were on Epstein's planes, at his properties, documented in his network, and who have never faced a single legal consequence for any of it. Dean also states that the unredacted files contain evidence that the president lied about his presence on Epstein's aircraft. That claim has not been proven or adjudicated anywhere. But here is the point that matters regardless of where you stand. If the documents are being withheld, no one outside the DOJ can verify whether that claim is true or false. Non-transparency doesn't just hide information, it makes accountability structurally impossible. The darkness is the mechanism. And then there is the third accusation Dean raises, the one I think is actually the most consequential, and the one that got buried because the exchange moved so fast. No one else has been prosecuted. Jeffrey Epstein ran a trafficking network for decades and did not run it alone. He had facilitators, recruiters, people who transported victims, people who knew and benefited and said nothing. Ghislaine Maxwell was convicted in December 2021 on federal sex trafficking charges and is currently serving a 20-year sentence. But beyond Maxwell, the prosecutorial record against Epstein's wider network is completely empty. No additional charges. No additional indictments. The investigation into Epstein's co-conspirators, the very document Dean is holding up, has produced no visible courtroom result. Dean opens her remarks by reading the final written words of Virginia Giuffre, one of Epstein's most prominent accusers, who died earlier this year. Giuffre wrote that she hoped for a world where predators are punished rather than protected, where victims are treated with compassion rather than shame, and where the FBI's confiscated videotapes from Epstein's homes would lead to the prosecution of more abusers. Those words were published posthumously. Giuffre spent years fighting for accountability in a system that was supposed to deliver it, and she died before it did. And the man now running that system told Congress today that they are fully compliant with the law. Now let me walk you through what happened to Dean's time in this hearing, because the procedural mechanics are part of the story. She was cut off at 2 minutes and 10 seconds into her allotted time. She asked for 20 seconds back. The chairman said no. And this happened at the exact moment she was pressing Blanch on the loyalty question. I'm not suggesting the timing was coordinated. Hearings run under strict time rules and chairmen enforce them routinely. But I want you to notice the cumulative pattern. Dean requests document access and gets a supervised visit to blacked out pages. She asks about 3 million unreleased files and is told they are duplicates. She raises all of this under oath in a public hearing, and the clock runs out at the worst possible moment. No single piece of this is necessarily a conspiracy, but systems don't need to be coordinated to function as shields. They just need to produce the same result consistently. And the result here, every time, is that accountability doesn't happen. So what should actually change from here? First, Congress needs to amend the Epstein File Transparency Act to define publicly available with enough legal specificity that the DOJ cannot reinterpret it as a supervised visit to a blacked-out binder. If the law's plain language didn't produce actual public release, it needs to be enforced through the courts or strengthened legislatively, and that fight needs to happen now, not after another election cycle. Second, the redaction decisions being made inside the DOJ need formal Inspector General review, not review by the Attorney General's own office, but an independent examination of who is authorizing these redactions, under what legal justification, and whether victim protection statutes are being applied correctly or used as cover for something else. Third, The non-prosecution of Epstein's co-conspirators requires a documented public accounting, not a press statement. A formal explanation of what investigations are active, what the evidentiary barriers are, and what the realistic timeline looks like. We will always prosecute anyone we can is not an answer. It is a placeholder designed to sound like one. Here is what I keep returning to at the end of all this. Dean read Virginia Giuffre's words not as inspiration, but as evidence. Evidence that the system these survivors trusted has spent years finding procedural reasons not to finish the job. Giuffre is gone now. The videotapes the FBI confiscated from Epstein's homes have never surfaced in any public proceeding. The co-conspirator file is mostly black ink. And the man who spent $10 million defending the president is sitting in the chair that is supposed to be independent of any president, telling Congress they have complied with the law. That is not a functioning justice system. That is a justice system that has been pointed at a purpose it was never designed to serve. And if that doesn't land as a warning, I don't know what will. If this breakdown gave you something real, subscribe so you're here when the next hearing happens. Because these moments move fast, the coverage moves on, and the details that matter most are almost always the ones buried in the procedural noise. I'll keep digging into them. Thanks for watching.